Thank you, and I want to thank Manlius Library for this opportunity to present to the community regarding a very important topic, which is the legal protections for immigrant victims of domestic violence. And although there's that word immigrant in that title, it's not just immigrants, it's broadly just non-citizens of the United States. So first, disclaimer. This presentation is not legal advice. It's only for informational and educational purposes. And if anybody has any questions, I highly recommend that you contact an attorney for advice. So this is the overview of tonight's presentation. I'm going to start by discussing the abuses that non-citizens face. Some of them are ubiquitous in terms of abuses that non-citizens and citizens alike face, but there are some unique abuses that non-citizens face because of their immigration status. And then I'll speak briefly on the Hiscock Legal Aid Society's immigration program. And then lastly, I will delve into the protections and options available to domestic violence victims and survivors. So abuses suffered by non-citizens. As I mentioned earlier, they are vulnerable to the same kinds of abuse as everyone else. And that abuse can be physical, emotional, sexual, and other kinds of abuse. But because of their immigration status or lack thereof, that can be as an extra weapon of power and control that the abuser could wield against the non-citizen. So I'm going to just list some unique types of abuse suffered by non-citizen survivors. And I want to provide this background because before we go into the protections and options offered by the US government, I think it is important to see why those kinds of protections and options are essential. So that to give that kind of information, I think it's important to go through the types of abuses that non-citizens face. So the types that the examples of some abuse that non-citizens can face include that they are prevented from learning English. The abuser could disallow the victim from contacting and speaking with friends and families in their home country. The abuser could threaten to report or actually report to ICE or to police about their non-immigrant, non-citizen spouse or a family member. They can withdraw or threaten to withdraw applications or petitions for a lawful permanent residency, commonly called green cards. And the abuser could falsely file criminal charges to get the victims deported out of the United States back to their home country. The abuser could also destroy victims' important documents that are necessary to either maintain their current status or obtain legal status in the future. Furthermore, the abuser could lie to victim that if the victim reports abuse, that they suffer abuse, that the victim will be deported, that they will lose residency or green card, or they might lose citizenship. So they threaten that these things might happen if the victim ever reports abuse to the law enforcement. Also, the abuser could get the victim fired from job by reporting their unlawful status, undocumented status to employers. The abuser could tell victims that reporting abuse to law enforcement will get not only them deported or their children deported. The abuser could tell victim that they cannot get custody of children because of their undocumented status. The abuser also could provide inaccurate or false information in English to those in positions of authority, which might include the police, the doctors, when independent interpreters are not easily available. Also, the abusers could threaten to have the victim deported while the abuser remains in the United States with their children. It's important to remember, though, that non-citizens, regardless of immigration status, so they do have rights under the US Constitution and federal statutes. Under the US Constitution, all people in the United States, regardless of immigration status, are guaranteed protection from abuse under the law. Any victim of domestic violence, regardless of immigration or citizenship status, can seek help. Undocumented victims have the same access to court system as everyone else. An immigrant victim of domestic violence may be eligible for immigration-related protections. And I'm going to discuss about those protections that are currently available to these victims and survivors of domestic violence. So I think it's important to also note that the unique fear, vulnerability, and safety issues that non-citizens feel, and the reason why they do not, that they may not contact for assistance or seek help. So the domestic violence survivors who are not citizens may fear being deported if they try to get a restraining order, a divorce, or custody of their children. They fear that courts and agencies will use their immigration status against them. So, for example, like during, let's say, child custody hearing, if one of the parents do not have lawful status in the United States, the court might think that it is not in the best interest of their children to award custody to that non-citizen parent, and things like that might be on their minds of these non-citizen parents. So also there have been instances where ICE, which briefly before was mentioned as the acronym for Immigration and Customs Enforcement, they might appear in a court proceeding. So there have been instances in the past where they have appeared in court proceedings, where they have been getting people while they were going to their court hearings and things like that. So that is of concern to many non-citizens. I would like to discuss what the Hiscock Legal Aid Society Immigration Program does in our community. So we are funded by the Office for New Americans in the New York State. And we currently have 9 attorneys who exclusively serve the immigration program. So if you look at the map of coverage regions, you will see that all the color regions, the red, blue, and orange, are regions that the Hiscock Legal Aid Society immigration program currently serves. So we do serve a big area of the New York State. And we do have access to interpretation and translation services. So if any non-citizens are not comfortable with speaking English, or if it's not their first language, we do have ways to communicate with them in a more accurate way. So the way that our immigration program serves the community is that, one, we provide free legal consultations to those who are eligible and who are looking to obtain some legal advice. And 2, we do provide community information sessions on immigration law topics, which is one like the one that's happening right now. And that might include also know your rights materials. So we do provide information sessions on rights of non-citizens when, for example, when they encounter ICE in various locations, and we provide information sessions on that topic. 3, we also provide staff and group trainings on immigration law topics. And 4, we provide free representations at the U.S. Citizenship and Immigration Services, that is also commonly called USCIS, and the Buffalo Immigration Court. So although our immigration program provides legal services in various other topics, in addition to these that are listed, but these are the ones that are that would be of interest tonight, that would be related to protections and options for domestic violence victims and survivors. So So I'm going to be going through these in more detail in the coming slides. So I'll be talking about self-petitions for legal status under the Violence Against Women Act, commonly called VAWA, battered spouse waivers, cancellation and removal under VAWA, U, non-immigrant status, U visa, which is for crime victims, and T, non-immigrant status, T visa for human trafficking victims. So VAWA self-petitions. Usually when let's say a non-citizen marries a US citizen or a lawful permanent resident, commonly called green card holders, the regular way, or the way that they have to go through, is to have the US citizen or the lawful permanent resident to file petition for their non-citizen spouse to gain lawful status. But under the Violence Against Women Act, the immigrant victims of domestic violence are allowed to file their own petitions for residency without cooperation of abuser. So this is a protection that is offered to victims of domestic violence. And it also allows parents to file petitions for themselves and their children if the children are the only ones abused. So that kind of broadens the protection by saying that even if the US citizen spouse or lawful permanent resident spouse abuses only the children, the parent of that children can also benefit can also get protection by self-petitioning for their own permanent residency. To qualify for this provision in VAWA, the victim must show the following. So they must first show that they're a victim of domestic violence, and then they must also show that they have relationship with a US citizen or green card holder. And this has been defined as either US citizen spouse or former spouse, so either current or former, US citizen parent, US citizen son or daughter, lawful permanent resident spouse or former spouse, or lawful permanent resident parent. So that shows that it's not just between spousal relationships, so it does extend to parent-child relationships for protections. The self-petitioner must be physically present in the United States at the time of filing, and they must have resided with the abuser. And if it's based on, if it's a spousal relationship, the self-petitioner must show that it was a good faith marriage and not, there was no marriage fraud or sham, that it was that they did not marry for the purpose of obtaining immigration benefit only. Also, the self-petitioner must show that they have good moral character. So although it is a Violence Against Women Act, this legislation is not limited to only women, and petitioners and perpetrators can be can be of any sex or gender. So so if approved, this VAWA self-petition has the following benefits. The self-petitioner will be placed on a lower priority for removal. They will obtain work authorization. They will also have access to federal and state benefits and services, and that might even happen sooner than the approval of their self-petition. So they might have access to those federal and state benefits even before approval. And then, as I mentioned, they have ability to apply for green card, so obtain permanent residency. And also they can apply for children to receive permanent residency, even if they're not already in the United States. So that is a further broader protection for the children of those self-petitioners. Battered spouse waivers. So before we speak about this, I do want to explain that when a US citizen or a lawful permanent resident petitions for their spouse to obtain a green card, if the marriage is 2 years or less, less than 2 years, at the time the green card is issued, it is a conditional green card. So conditional residency is a 2-year residency instead of the regular 10-year residency. It's not that their permanent residency ends after 2 years, it's just that after 2 years, within 90 days of expiration date, they have to file for petition to remove conditions on their residency. So there is that requirement if the marriage is less than 2 years. And usually when they petition to remove their conditions, it is necessary to do it jointly with their spouse. But this waiver allows a non-citizen who is a victim of domestic violence to petition for themselves without depending on their spouse to do it jointly with them. So this is available for immigrant victims who have conditional residency. And conditional residency was obtained through a case filed by their abusive US citizen or lawful permanent resident family member. So as I explained, victim can petition to have the conditions removed and have their conditional residency changed to permanent residency without abuser's knowledge or participation in the process. And I'm going to speak a little bit about if the non-citizen who is a victim of domestic violence is in removal proceedings, or also called deportation proceedings, the provisions under VAWA can provide protection for those in removal proceedings so that they can apply for a cancellation of removal or suspension of deportation under VAWA. So when let's say the non-citizen is in front of an immigration judge in immigration court, they can raise this as a defense and ask the immigration court to cancel removal or deportation process and grant the non-citizen a green card instead. These are the eligibility criteria that's listed in the middle of the slide. So first, the non-citizen must be in removal proceedings. They must have family relationship with the abusive parent. They have an abusive parent or abusive current or former spouse, or their partner is, they're the parent of abused child. So if if the person in removal proceedings has a child who was abused by the US citizen or lawful permanent resident perpetrator, they can put this as a reason to cancel, or as an application to cancel removal. So even if the person in deportation proceeding is not married to abuser, they can still obtain relief from this. The next requirement is that they must show that there was some extreme cruelty that they were subjected to or their children were subjected to by the abuser. So it can be either physical or emotional violence. And the last one is, I think this is a very difficult element to prove, that they must show that there will be an extreme or unusual hardship to the victim or an eligible family member if the person in removal proceedings was deported. So, so the eligible family member is specified as either a child who is a US citizen or a lawful permanent resident, or the non-citizen's parent or their spouse. But the requirements are less demanding than self-petition as the person is in removal proceedings. The next one I want to talk about is the U non-immigrant status, or U visa. So this is a temporary immigration benefit that, if approved, the person who obtains the U visa has 4 years of temporary non-immigrant status, and they will have work authorization incident to status. And those who are eligible must show the following. So first, they have to be a victim of qualifying criminal activity which are usually serious in nature. So these are just some of them: abduction, abusive sexual contact, domestic violence, false imprisonment, felonious assault, incest, kidnapping, prostitution, rape, sexual assault, sexual exploitation, stalking, trafficking. So they must show that they are a victim of qualifying criminal activity, that due to the criminal activity, they suffer substantial physical or mental abuse. They have some information about criminal activity that law enforcement is interested in solving or investigating, and that the U visa applicant is or was in the past or is currently or will in the future likely be helpful to law enforcement in investigation or prosecution of crime. And the qualifying crime must have occurred in the United States or violated the US law. One benefit is that for this visa can be applied from within the United States or while abroad. But the difficult component of this obtaining this visa is that the U visa applicant must obtain law enforcement certification that they were either in the past or is currently or will likely in the future be helpful to law enforcement in investigation or prosecution of crime. So certain qualifying family members are also eligible for something called derivative U visa. So there's that word derivative, saying that there's a principal U visa applicant who is the victim of the qualifying criminal activity, but then certain family members could be qualified as derivatives of that principal applicant based on their familial relationship. Also, it's important to note that there's a U visa cap. There's a limited number of U visas that the federal government has designated that may be granted to principal petitioners annually. And these numbers are, there are very few visas for very many applicants. So these caps are reached very quickly, and some U visa applicants have been waiting 4, 5, 6 years to just even get a U visa. So there is a very long wait time for this visa currently. After 3 years of continuous physical presence in the United States, after getting approved for U visa, the U visa holder is eligible to adjust status, which means that they are able to apply for green card or as a lawful permanent resident status. So that is a huge benefit to this non-immigrant status, that there's a path to permanent residency. T non-immigrant status, or T visa, is similar to U visas in I guess the way it is the way it is structured and the way that it's a path to green card. So like U visas, it is a temporary immigration benefit that provides up to 4 years of temporary non-immigration status. And it also has the work authorization that is incident to the status. So and also like the U visas, the T visa holder have access to federal and state benefits and services. And those who are applying for T visas, they are eligible if they showed some of these requirements. So they are either currently or in the past was a victim of severe form of trafficking in persons. And trafficking can be either commercial sex or labor trafficking. The applicant must be physically present in the United States or certain US-owned territories. And that they must be in the United States on account of human trafficking. They must have complied with any reasonable request from law enforcement agency for assistance, investigation, or prosecution of human trafficking. Although it's not required to have a law enforcement declaration, it is highly encouraged to obtain that from a law enforcement. The eligible person should demonstrate, is required to demonstrate that they would suffer extreme hardship that involves unusual and severe harm if they were removed or deported from the United States. Also similar to U visas, T visa holders can have certain family members who can be qualified to obtain a derivative T visa based on familial relationship. And the family members who are looking to become derivative T visa holders, they do not have to be present in the United States at the time of application. And also similar to U visa, the T visa holders are eligible to adjust status to become lawful permanent resident or green card after 3 years of continuous physical presence in the United States. So those are some of the information regarding the protections and options available for non-citizens who are victims and survivors of domestic violence. And if you or you know somebody who might want to discuss with an attorney for their situation and have a confidential consultation, they are welcome to contact the Hiscock Legal Aid Society Immigration Program. And you can call the number that is shown there, which is 315-218-0152 or 315-218-0196. And we can screen you for eligibility and then have you scheduled for an appointment to speak with an immigration attorney. The other option is also to call the New York State New Americans Hotline. This is a confidential anonymous hotline for non-citizens in New York State, 1-800-566-7636. And the hotline does a lot of things. They provide answers to general immigration and naturalization questions, although they do specifically say that they do not provide any legal advice. They also provide referrals to free legal help and programs in your area. They do provide information about nearby opportunity centers. Opportunity centers do a lot of things. They can provide assistance with, like, for example, like citizenship courses. They do provide citizenship courses, so in English courses, and maybe even some help with like employment, obtaining jobs, or other social services related things. Like there is a lot of resources that are in those centers that are available for non-citizens. Also, New Yorkers can call that hotline to report fraud or scams against immigrant communities. So there has been a lot of report about people trying to make profit out of against the immigrant communities by illegally offering legal assistance when they're not authorized, when they don't have license to be attorneys. These things are reported once in a while, and does happen. The great thing about this hotline is that they have interpretation services provided in 200+ languages. And as I mentioned, the calls are confidential and anonymous, so non-citizens can call without fearing that their information will be released or shared with others. So the hotline is open Monday through Friday, 9 a.m. to 8 p.m. Eastern Time. So that is all for today. Thank you very much. And as I mentioned, please feel free to call our Hiscock Legal Aid Immigration Program or the New York State Office for New Americans hotline to obtain further legal information or advice. Thank you.